Declaration of Independence from NEUROLAW and Technological Tyranny. I, Mark Andrew Rackley, the living man, standing as a free and sovereign being endowed by my Creator with inalienable rights, do hereby declare my absolute and final independence from any and all neurotechnological systems, biometric surveillance, frameworks, cognitive intrusions, and so-called NEUROLAW regimes, whether domestic or foreign, public or private. I reject any contract, statute, ordinance, executive order, corporate policy, international agreement, treaty, foreign regulation or technological platform that attempts to override, subvert, bypass, digitize, encode, monitor, record, modify, interfere with, or otherwise trespass upon the sacred domain of the human mind. I assert that neuro-liberty is an inherent and unwaverable right of every living man or woman. My thoughts are private property. My cognitive processes are sovereign. My memories are not subject to indexing, storage, deletion, or seizure. My identity is not a corporate construct. My brainwaves are not a commodity. My neurological signature is not evidence. I hereby declare all agreements, contracts, click wraps, and end-user licenses, medical releases, data terms, privacy policies, and technology terms, whether signed, clicked, scrolled, presumed, or coerced, regarding neurotechnology, biometrics, brain data, to be null and void, ab initio, unless supported by explicit written wet ink informed consent of the living signer. This includes any presumed or artificial consent resulting from future incapacitation, imprisonment, medical restraint, or mental impairment. The absence of communication or perceived compliance shall not be construed as agreement under any circumstances. I affirm, 1. That invasive integration of human biological material with machines, neural meshes, implants, or nanotech is a violation of my bodily or sovereignty and shall be treated as an aggravated assault. 2. That non-invasive devices which read brain data, cognitive patterns, or biometric signals shall not be imposed upon me without full disclosure and written, voluntary, non-coerced, informed consent. 3. That all forms of NEUROLAW as applied to living men and women are hereby rejected in whole and shall no force or effect. That AI or synthetic approximations of human consciousness, behavior, or memory shall never be used to impersonate, replace, or profile me. That sovereign immunity, qualified immunity, corporate shield, or any such legal fiction shall not protect perpetrators of cognitive trespass. That the Constitution for the United States of America, the Magna Carta from 1297, is the only lawful foundational charter that sources my rights. Accordingly, I incorporate the full cognitive library opposing Neurological Exploitation Act, the C.L.O.N.E Act of 2025, as amended, and attach it to this declaration as Exhibit A. All definitions, provisions, bans, enforcement clauses, committee structures, and criminal penalties outlined therein are adopted by reference as an extension of this declaration. Let this serve permanent notice to all parties. My non-consent is explicit, irrevocable, and unaltered by time, condition, incapacity, or coercion. I declare my right to live free from technological oppression. I exercise my natural authority to say no to cognitive tyranny. I record this declaration publicly to serve all courts, officials, governments, corporations, and artificial entities. The human mind is not your jurisdiction. This declaration is my living testimony, witnessed by my signature, my sign nature, and sealed by my breath. As of 31st of October, 2025, 9 Mitchell Avenue, Dunedin, New Zealand.